Okay, I'm back. Hopefully, the connection is a little better this time, though it doesn't really appear from my end that it is. I tried to do a live video here a little while ago, and the connection was apparently terrible. So I shut it off. I'm now hardwired with my other internet connection, but that's also not apparently very good. So is it? Yep, it's still blurry. That's just a bunch of garbage. Well, I guess I'll just have to stop doing any live videos, not that I was, except at my other office that has sufficient internet. It's just crazy because, I pay out the yin yang for every available internet connection here at my main office, and none of it works. At least when it gets scratchy video wise like this, if I put a document up on the screen, it usually looks pretty good. Let me try that. So that really was the first thing that I wanted to talk about, and that is the now infamous AR15 open carry case that I've been litigating in the Fourth Circuit. This is the Walker versus Donahoe case. This is the case where we received that awful opinion from the Fourth Circuit that was basically a diatribe against the AR-15, and it ruled, against us and in favor of the deputy out of Putnam County, West Virginia, who was caught on video doing what he did to my client. If you haven't seen the video, you can watch the video. But really, it was a just an awful opinion, and this is a panel opinion, so it's three judges on the Fourth Circuit who heard the oral arguments in the case and who drafted the opinion and signed on to it. Now, the opinion was drafted by Judge King, and that was the judge, if you watched or listened to the oral arguments, the one that was comparing the AR-15 to the M16. So I knew that when I saw the particular judge on the panel who drafted the opinion that it was not going to be good. Now, there was one judge who was appointed by Trump, who's obviously a new judge on the Fourth Circuit, Judge Richardson, who was on the panel. Now, he concurred in the opinion because he said he would have granted qualified immunity, but did not concur in the issue of whether or not this was a civil rights violation. So where we're going now is, once the U.S. Circuit Court of Appeals rules against you, you then have 14 days, at least here in the Fourth Circuit, to take action. So 14 days to file really the only other thing that you can file, which is a petition for rehearing in the Fourth Circuit. So this is the document up on the screen that I filed, and it's a petition for rehearing en banc. And what that means is it's a request for the entire Fourth Circuit to sit as a body and hear the case, basically throw out the opinion, the panel opinion that they issued, and sit together and hear the case. And the reason that, usually that's a Hail Mary, but the reason why I thought it might work in this case is because really the opinion in our case effectively castrates really the only good gun rights case that we have in the Fourth Circuit, and that is United States versus Black. It basically says, yeah, well, U.S. versus Black says that the police can't, stop you and ID you just because you're carrying a firearm in a state where you're allowed to carry a firearm, at least not without more. And so what they've done is they've taken the words without more and they've stretched that to effectively swallow the entire holding of the case. So anything can be without more is where they came down with this decision. So this is the case where my client, Michael Walker, was walking down the side of the road. He was headed coyote hunting with his friend in Putnam County, West Virginia, suburban really area of West Virginia, which is an open carry state. And it's legal also to open carry AR-15 style rifles in West Virginia. So absolutely nothing illegal about that. Now, what happened in this case is Deputy Donahoe, after somebody had called 911 to report a man with a gun, basically didn't report any illegal conduct, no allegations that crimes were committed, just somebody walking down the side of the road with a gun. So when he shows up, he takes the position that he can stop and ID him and ask him questions, run his criminal background check to see, in his own words, whether or not he was a prohibited person, meaning a felon in possession of a firearm. Now, he didn't know Michael, didn't have any information that he was or was not a prohibited person. Now, that's important because United States versus Black, which was a Fourth Circuit opinion, a panel opinion from 2013, held that let me state it this way, that being a felon in possession of a firearm or being suspected of being a felon in possession of a firearm is not the default status. So unless police have reasonable suspicion that you have committed a crime, then they can't stop and detain you and run a criminal background check on you. And the reason US versus Black was issued in the first place is because cops would go into what they would call a high crime area and they could racially profile people and say, oh, well, there's a Black guy with a gun. I've never seen a Black guy openly carrying a gun before, and I thought it was suspicious. No, you can't do that because you can't assume that the person who has a gun in a state where it's lawful to have a gun and to openly carry a gun, and it's a type of gun that's lawful to possess in that state, you can't just assume that they might be breaking the law. Why? Because, well, what's it based on? Is it going to be? It's going to be based on racial profiling or some sort of other profiling. Whereas the Fourth Amendment requires particularized articulation of suspicion. That's particular to the individual, the suspect. It can't be generalized. It can't be categorical. That's what's not allowed. And that was made very clear in United States versus Black from 2013. So Deputy Donahoe in that case said over and over again, look, anytime I see an individual with a gun, I can stop and ID him. And I can run his background to see if he is a felon, if he's allowed to possess that gun or not. Don't tell me I can't. If you want to test me, I'll hook you and book you, and you can test it out in the courts. That's basically what he said. I'm paraphrasing, but he was absolutely wrong. The law said specifically and expressly the opposite, that he can't do that. Yet in the end here, at least so far, he got away with it. And why did he get away with it? Because where the Fourth Amendment intersects with the Second Amendment, where the Fourth Amendment intersects with gun rights, we have this weird paradox, or this Bermuda Triangle of constitutional rights, where you have judges who would otherwise stick up for the rights of Mr. Black or Mr. Curry in another case in Richmond. They apparently weren't willing to stick up for Michael Walker in Putnam County, West Virginia. Now, why are his rights less important than Mr. Black's rights or Mr. Curry's rights? And that is where I went with this petition for rehearing en banc before the Fourth Circuit, because you know what? It's absolutely wrong if they allow that opinion to stand. And so that's what I went through here. And this is posted in the description, I believe it should be, at the website at thecivilrightslawyer.com. But I go all through that. And with these en banc petitions, it's sort of, like I said, a Hail Mary of trying to get them to rehear the case. But it does buy you some more time to prepare an appeal to the U.S. Supreme Court. And, it's worth a shot. But what I really wanted to point out here is that, look, you can see disparate treatment of my client versus these other two guys from United States versus Black in 2013, and also the more recent case, which was an en banc case, United States versus Curry from 2020. Both of those cases forbid the suspicionless seizures of individuals based on improper or insufficient, non-particularized, general, and categorical assumptions by police officers. So in 2021, do we really want to give police officers the ability to subjectively suspect us of criminal conduct? Completely subjective to them. You can't demonstrate it that it's particular to any suspect, but it's just something in the back of their mind. Do we really want to give them that power over us to be able to detain us and get our ID, run our background, just because something in the back of their head tells them that we might just, in some general terms, be a criminal? No. And if you look at United States versus Black and United States versus Curry, they explain why that is improper under the Fourth Amendment, because it's generalized. They're assumptions. It's racial profiling, no matter the skin color. And so I wanted to point out to the court here that this panel decision that we received is absolutely contradictory to not only the Black case, but also United States versus Curry. And that, again, was from 2020. And that was where this guy Curry was in downtown Richmond, or maybe near some housing projects in Richmond, and there was an actual active shooter on the loose. There were gunshots going off. There were narcotics officers who I believe were out of uniform that were nearby. They rushed to the scene. They saw Mr. Curry, who was a Black man, with several others walking sort of suspiciously away from the scene. Didn't observe them commit any crimes. The one, I believe it was Mr. Curry, looked like maybe he had a wound to his arm that he was favoring. And so they stopped them. They detained them. And the ultimate holding here is no, there was no reasonable articulable suspicion that was directed to this actual suspect. All they had was generalized categorical information that there was a shooting that happened and that this was a high crime neighborhood, that this individual was in the vicinity. That's pretty much it. The police officers weren't allowed to string their suspicions together in their head that, all right, well, I suspected these guys just because I got a hunch about them. No, they weren't allowed to do that. In United States versus Black, the government was chastised strongly by Judge Gregory for doing that. But here it has been embraced with poor old Michael Walker. Now, why? Is it because of his skin color? Is it because he had an AR-15 style rifle, which the judiciary apparently doesn't like? I don't know. But the end result is that Michael was treated differently. He was vilified as a potential mass murderer of children based on what the Fourth Circuit has already called improper factors. And in my argument, that created and creates a two-tiered system of reasonable suspicion, which does discriminate between a suspect's appearance and their neighborhood. And that's not allowed according to both the spirit and the letter of the holdings of the Black case and the Curry case. What they've created here is also a diminished Fourth Amendment protection for individuals who are in possession of AR-15 style rifles throughout the Fourth Circuit, which is West Virginia, Virginia, Maryland, North Carolina, and South Carolina. And that flies in the face of the fact that AR-15 style rifles are legal to possess in West Virginia and also legal to openly carry. For instance, if you're walking somewhere to go coyote hunting, and it doesn't matter. It's not reasonable suspicion of criminal conduct just because somebody is openly carrying an AR-15 that's legal to open carry, as opposed to a shotgun or a bolt action rifle, or even a handgun, all of which are legal to open carry. So they've created a diminished Fourth Amendment right for somebody who's in possession of an AR-15 style rifle. And it's not based on conduct that officers observed the suspect commit. It's not based on that at all, which it's required to be. It's based on a police officer's ignorant assumption or fear of the scary black rifle because there was a school shooting with an AR-15 style rifle. So therefore, that police officer was subjectively scared that there would be a copycat shooter. That's effectively what the court has ruled here, that because this police officer, who clearly didn't suspect that, who clearly was checking to see if Michael was a felon in possession of a firearm, which he's not allowed to do, and who clearly acted like a complete jerk on the video, they've allowed a police officer to, after the fact, even make up a claim that, well, there was a school shooting a month earlier, therefore I was subjectively afraid that he could be a copycat shooter, even when that's not supported by the underlying facts. So because firearms are involved and we're in this Bermuda Triangle of constitutional rights, Michael is getting treated differently here in this holding than Mr. Curry or Mr. Black, both of whom I believe had actually committed some crime, in fact, and had been prosecuted. So those were criminal cases. This is a civil case. Michael Walker undisputedly did absolutely nothing wrong, broke no law, yet he was detained and treated like trash by a police officer, and now vilified in court orders as a suspected murderer of children. And it's absolutely created out of thin air. It had nothing to do with the underlying facts of the case. So I'm asking the Fourth Circuit to, and I hope that the author, Judge Gregory, of the Black decision will be one of the judges who votes to hear this case en banc, because this opinion effectively destroys the opinion that he wrote in 2013, because it says that police officers can create, quote, more out of any subjective fear that they have, even if they don't really hold it. You know, it's absolutely, that's like saying, okay, police officers are now allowed to racially profile so long as, you know, they have some sort of fear in the back of their mind that they can testify to later. I mean, it absolutely cannot be allowed, because it completely swallows the entire, you know, Fourth Amendment protections surrounding reasonable suspicion and the requirement that there has to be individualized facts articulated as to why you're detained. So that's where we are with the Walker case. When you file one of these petitions for rehearing, it puts an automatic stay on what they call the mandate. So the panel decision, as of right now, because we filed it timely, it's stayed to give the court an opportunity to vacate this panel decision and to rehear the case before all the judges. And I really hope that that happens. If that doesn't happen, then we're seriously considering appealing that case to the United States Supreme Court. So that's what's going on with the Walker case. And I encourage you to read our petition for rehearing that's in the link. The other case I wanted to give you an update on is the vaccine mandate litigation that's currently going on. Now, this is right now pending in federal court in the Southern District of West Virginia. This is the case involving my client, Stephanie McCutcheon. It was originally filed in state court because it's a state court claim. There we go. Now, this is something that's due tomorrow. So this hasn't even been filed yet. So I'm sharing what is basically a draft here. This has not been filed yet. So the Chicago company that operates the Seasons Place assisted living facility in Greenbrier County, West Virginia, they fired my client, Stephanie McCutcheon, for not getting the emergency use authorized vaccine. They actually fired her. She is now fired. So we filed a challenge to that state law, basically a wrongful discharge lawsuit based on what's called retaliatory discharge. And this is very similar to the vaccine mandate lawsuit that was filed in federal court in Texas, or I don't know if it was filed or removed there, but it lost in Texas. And it was actually the district court judge who is the most reversed district court judge in that entire circuit who ruled against the plaintiffs in that Texas case. But in any event, they have this Chicago company Enlivant has cited that ruling. And so I've distinguished it here because although we're talking about federal law, whether vaccines can be mandated under federal law, we're also talking about, but we're talking about a state law claim, and that's what's distinguishable. So in Texas, they had no exception to the at-will employment doctrine that was just based on public policy, something that could include the part of federal law that says you can't mandate vaccines or you can't mandate emergency use authorized products. The Texas law basically just said that you can't fire somebody if it's an actual criminal violation or if it's in retaliation for a criminal violation. So it was different, and that's what it was based on in Texas. So ours is completely different here. It's literally based on West Virginia state law, and the claim is retaliatory discharge. So we all know this by now. 21 USC 360 BBB3, this section of the federal code. So this is what is at issue here. Okay, that is the part of the federal code that says that emergency use authorized products such as vaccines are not to be mandated, or that people are to have an option. Now, the argument from the other side is, well, yeah, federal law says that, but it doesn't apply here. It doesn't apply to private employers, and private employees cannot enforce that section of federal law. So that is the argument that's being made. But my response to that is that's irrelevant. It doesn't have to, because West Virginia's law says that, yeah, we're usually an at-will employment state, but here's an exception. This is the case in West Virginia that created the exception, Harless versus First National Bank from 1978. And it held that the rule that an employer has an absolute right to discharge an at-will employee must be tempered by the principle that where the employer's motivation for the discharge is to contravene some substantial public policy principle, then the employer may be liable to the employee for damages occasioned by this discharge. So yeah, generally, an employer in West Virginia, as many other states, can fire an employee for any reason that they want to. However, we know that they still can't fire somebody because they don't like you because you're a female, or they can't fire you because you're Asian and they're bigoted towards Asians, because those violate other federal statutes. Now, in West Virginia, we have this thing in our law that says, even though we're an at-will employment state, if an employer's motivation for discharging an employee is to violate a substantial public policy principle, then you can have a lawsuit, basically. So then the question becomes, all right, well, how do we know what substantial public policy principles are? How is that defined? Well, there are cases on this. The West Virginia Supreme Court has identified the topic areas from which we can establish what West Virginia public policy is. So the sources that determine public policy are, among other things, our federal and state constitutions, our public statutes, our judicial decisions, the applicable principles of common law, the acknowledged prevailing concepts of the federal and state governments relating to and affecting the health, safety, morals, and general welfare of the people for whom government with us is factually established. So it's pretty broad. All federal and state constitutions, statutes, all judicial decisions, all applicable principles of common law, any acknowledged prevailing concepts of federal and state governments relating to safety, health, morals, general welfare. So that is a very, very broad definition of what public policy is, or substantial public policy is in West Virginia. In Texas, they didn't have that. They didn't have that. Here in West Virginia, we have utilized our state, that this exception that exists in state law. And why does it exist here? Because West Virginia has been run by Democrats for decades. What does that mean? That the trial lawyers, the personal injury lawyers, the medical malpractice lawyers had run rampant in this state for generations. And this is what came out of it. This is one of the ways that they had chiseled out an exception to be able to sue employers for firing people. They just had to show, if they couldn't show it was because of skin color or sex, they could show that it was in violation of some public policy. So the trial lawyers had gotten themselves some ammunition here to form the basis of wrongful discharge lawsuits. But now we're using it for the purposes of protecting the individual right to choose not to take the unapproved experimental vaccines. So it's a broad definition, can come from anywhere in statutes, the Constitution, and also legislatively approved regulations and judicial opinions. It's not just recognizable as such, but widely regarded as to be evident to employers and employees alike. Okay, it's supposed to give specific guidance to a reasonable person as to, the fact that substantial public policy exists. All right. Now, what are we alleging is a substantial public policy? Well, obviously, this is 21 USC 360 BBB3. That is the spot in federal law, federal code enacted by Congress, where Congress said that potential users of an EUA vaccine must be informed that they have the option to accept or refuse a vaccine. And that's it, period. So we have a federal statute. And how can a federal statute, under the definitions that I just read, not include or not consist of a substantial public policy? It's federal law. Regardless if a private employee is allowed to enforce that law, which she's probably not. It doesn't matter, because we're not trying to enforce that law through a federal claim. We filed a state law claim in West Virginia. A state law claim that just points to a federal law to consist of a public policy. So yeah, it's kind of legal gymnastics, but that's what you have to do. That's what you have to do to fight this tidal wave that is the government just rolling over our individual liberties here. So Congress created, and this actually comes from the Biden administration. They lamented about this. Congress created a scheme in which potential users of an EUA vaccine must be informed that they have the option to accept or refuse the vaccine. Now, if you look at the memorandum opinion by the DOJ that was just issued on July 6th, they lamented this. They're like, all right, this is what they said. If you look at footnote 1 that I've put in here, our reading of Section 564 does not fully explain why Congress created a scheme in which potential users of the product would be informed that they have the option to accept or refuse the product. The legislative history of the 2003 statute does not appear to offer any clear explanation. So here the Biden DOJ is looking for this explanation as to why Congress would have done such a thing. Well, if you look at the statute itself, it says it's to protect the public health. Where is it? All right. So this is the statute itself, 21 U.S. Code 360 BB3, authorization for medical products for use in emergencies. Okay. That in the first paragraph, it says, where is it? The secretary finds necessary or appropriate to protect the public health, including the following. So this is what Congress has put in place to protect the public health. The last one here is that potential users of an EUA vaccine have to be informed of the option to accept or refuse administration of the product, the vaccine. Now, why would Congress direct that potential users of the vaccine be instructed and informed that they have an option to accept or refuse that product if they don't actually, according to the Biden DOJ, have an option? So how can it be an option if it's not an option? On the one hand, you have what Congress wrote, and then on the other hand, you have the Biden DOJ trying to find a way around that or trying to explain why Congress would have done that when obviously Congress didn't intend to do that, is their argument. But that's what it says. So even though my client is not a federal governmental entity that is entitled to enforce this law, it doesn't matter because it is a law. It is a federal law. And my client was deprived of any option to accept or refuse the administration of this emergency use product. And it matters not that it was a private employer that did that. Because again, West Virginia law, developed for decades by the trial lawyers, provides for an exception. All we have to show is that they did it with the motivation to violate a substantial public policy principle. Substantial public policy principles are defined as anything in our state or federal constitution or our state or federal statutes. So here's a federal statute right there. Ms. McCutcheon was deprived of any choice, any freedom to make her own personal health choice in regards to wasn't given a choice. She was given a mandate. And we've documented that in the complaint. If you want to review it, they put it in writing. They sent her a letter that says, you're going to get the vaccine. You're not going to work here anymore. Now, what they've done is something that there's another federal decision that's out on the vaccine mandates, and that was out of Indiana, regarding 8 students who sued Indiana University. And the federal judge in that case had concluded that, well, the students still had a quote unquote choice. They could choose not to go to school that semester. And likewise, this Chicago company here, Enlivant, has made the argument that Stephanie McCutcheon still has or had a choice. She could choose to be fired. That's still a choice. Is that not still a choice? And, it strikes me as that's like saying, all right, let's apply that to another area of our jurisprudence, of our federal law. For instance, the Fourth Amendment. Everybody knows, or most people know, that voluntary consent, is an exception to the general rule, the per se default rule that warrantless searches of a home are unconstitutional. As a rule, as a matter of law, that's the per se rule. Unless the government can establish that the resident of the home or the homeowner, the individual involved, gave voluntary consent for a warrantless search. So there's all sorts of court decisions out there on what voluntary consent is and what voluntary consent is not. And they all say that if there's coercion, you can't have voluntary consent. So that's like saying, all right, consent to us to come in your house without a warrant. But if you don't, we are going to, you know, throw you in jail and throw away the key or bring some other harm to you. And that's sort of the same thing as, somebody, for instance, waiving their Miranda rights. So they're being interviewed by the police. They're told you have the right to remain silent. Now imagine if, all right, you have the right to remain silent, but if you do remain silent, then you're going to be in jail for the rest of your life. Or I'm going to beat you. Or I'm going to beat your mother or your son or whatever. That can't be voluntary consent, can't be a voluntary waiver because it was obtained through coercion. It was obtained through fear. And it strikes me as the same logic here for these companies to argue, or for the federal courts to argue that, yeah, okay, federal law says that, or public policy says that, but the person technically did have a choice. They weren't literally strapped down and stuck with a needle. They were given the choice to be discharged from their only source of employment. So that, if we apply the voluntariness analysis to that, it doesn't work. It's literally not a voluntary choice. And when I was researching that, and again, this is something you're looking at this is going to be filed tomorrow. This is due tomorrow. This is our response to their motion to dismiss. And then once we file this, the federal judge will review it and make a ruling. Now, the Chicago company also made the argument that, well, all right, West Virginia public policy is pro-vaccine. And they pointed to our governor, Jim Justice, giving away millions of dollars and lifted modified trucks in his vaccine lottery. And they pointed to that as proof that West Virginia is a pro-mandatory vaccine state, and therefore it's public policy, or should be public policy in West Virginia, to encourage the mandating of vaccines. And that is, I can't argue with what our governor has done, but I can point to, at the very least, the governor gave me some ammunition to fire back at that with. Where did I put it here? All right. So they argued that West Virginia policy favors mandated vaccination. However, just 2 days ago, the news reported that Governor Jim Justice announced that he opposes vaccine mandates for state employees. And thank goodness he said that. I'm surprised he said that, actually. But he opposes vaccine mandates for state employees. That's what he said on July 26, 2021. Another thing that happened in the past few days, West Virginia Attorney General Patrick Morrisey was interviewed by radio host Tom Roten, who I appeared on his show early this morning, also on July 26th, and he declared that West Virginia should not require vaccine passports in order to travel or participate in certain activities. And I actually looked up WVU, the state's largest university, as early as March of 2021, announced that they would not be mandating vaccines for students and staff. And I checked today on their website to see if they held to that. And it looks like as of today, WVU's policy on their website provides that, quote, at this time, students and employees are not required to be vaccinated, but that university will reevaluate vaccination requirements upon FDA approval. So the largest university in the state, they're saying, well, they may require vaccinations in the future, but only after there's FDA approval. And that's what this case hinges on, really, is the fact that there's no FDA approval right now. And federal law says that the EUA authorization is not supposed to be mandated. That's federal law. Another thing that they argued here, which was kind of funny, is they quoted me, the lawyer for the plaintiff, in a TV news interview that I that gave the opinion that generally employers can mandate vaccines. And that's absolutely true. I did give that interview and I gave that opinion, but that's assuming that they're approved by the FDA. Every vaccine that's been mandated before has been approved by the FDA. And the fact is, prior to that approval, federal law says that you can't do it. And I point out here that if I was allowed to change West Virginia law just by virtue of spouting off my public opinions, well, individual citizens in West Virginia would finally get to live up to our state motto, Montani Semper Liberi, that mountaineers are always free, because we have not been living up to that. And we've been, we've been a commie state for the past year and a half. The fact is that there's no legal precedent authorizing any entity, whether public or private, to mandate vaccines that are unapproved and still in the testing process. Now, the case that they always turn to, whether it's the government or these employers, is that it's long been U.S. Supreme Court case law that the government can mandate vaccines. And they get that from the Jacobson case from 1905. So if you're interested in how to defeat Jacobson, or how to argue that Jacobson does not apply anymore, I've kind of laid it all out here. And I didn't create all of this whole cloth. I had some help. But here is the way to do it. So Jacobson, which was, they had forced Mr. Jacobson, or tried to force him, I believe it was to take a smallpox vaccine in Massachusetts in 1905. And it went up to the U.S. Supreme Court, and they said that basically the state police powers in Massachusetts do allow them to require mandate citizens to take vaccines. But again, that was 1905. 1905. The fact is that, and that's what's being used over and over again to substantiate all this COVID stuff that these governments are doing. But the fact is that Jacobson from 1905 cannot grant a blank check to governments, to state, local governments, to engage and to do anything they want to, whenever they want to. In fact, since 1905, as I lay out here, there have been all sorts of Supreme Court jurisprudence that found new individual rights that weren't even in existence in 1905. There was a case from 1927, another U.S. Supreme Court case called Buck versus Bell. And this is one of the really disgusting U.S. Supreme Court cases. This is from 1927. And, this is obviously after Jacobson, but it was using the same legal logic, the same reasoning that Jacobson was based on. It just extended that to basically involuntary sterilization of a woman who was purported to be low intelligence. And that was upheld by the U.S. Supreme Court. Now, since then, as I argue here, Buck versus Bell has been lambasted by the U.S. Supreme Court recently. And it's been criticized in many different decisions. And it's really the same thing as Jacobson. Same thing. There was a recent case, 2019, one of these, abortion type cases, Box versus Planned Parenthood of Indiana and Kentucky. That was 2019, U.S. Supreme Court. Okay. And they mentioned the Buck versus Ball case. And they noted that their court, the U.S. Supreme Court, gave a, quote, full-throated defense of forced sterilization. And they quoted the opinion by Oliver Wendell Holmes Jr. And I've included this in our brief here, and I'll read it to you. This is Oliver Wendell Holmes writing on behalf of the U.S. Supreme Court in defense of forced sterilization of a woman because she's, quote, low intelligence. We have seen more than once that the public welfare may call upon the best citizens for their lives. It would be strange if it could not call upon those who already sapped the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent our being swamped with incompetence. It is better for all the world if, instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. 3 generations of imbeciles are enough. That is your U.S. Supreme Court from 1927, using the same legal logic, the same legal basis as the Jacobson case that is cited all over the place now in defense of government being able to do whatever they want to in response to COVID. If that's allowed, why isn't Buck versus Ball allowed? Okay. The U.S. Supreme Court in 2019 noted, criticizing that, which I just read, that decision gave the eugenics movement added legitimacy and considerable momentum, and that by 1931, 28 out of 48 states had adopted eugenics sterilization laws. Okay. The fact is Buck's ruling, even according to the Sixth Circuit, has been repudiated. And as I read, even implicitly according to the Supreme Court. So to repudiate Buck versus Ball, the sterilization case, is the same thing as repudiating Jacobson. It's the same concept that there's no end to a state's police powers from a federal constitutional perspective, so long as there's an emergency, a public health emergency, and whatever they're doing bears a real or substantial relation to protecting the public health and public safety. Well, there's a typo. I forgot it now. All right. So Buck simply carried that same rationale from Jacobson to its logical conclusion. So if compulsory vaccination is broad enough, it also covers the cutting of fallopian tubes. So if courts now recognize that Buck has been repudiated, then courts must recognize that which breathed life into the Buck decision is also repudiated. So again, Jacobson was 1905. Since then, the Supreme Court has recognized numerous limits on the government's power to engage in these health and safety regulations, including the right against involuntary restraint, decisions about marriage, contraception, procreation, family relationships, sexual relationships, child rearing, education, as well as the right to refuse life-saving treatment. So these are all rights that were discovered by the U.S. Supreme Court long after, in most cases, Jacobson was issued in 1905. So federal law, federal constitutional law has evolved thanks to the Supreme Court, and therefore the implicit overturning of Jacobson has a basis in the law, and it's suggested by, by some decisions that are out there, including this great decision that I've talked about before from a case in the Western District of Pennsylvania, County of Butler versus Wolf, written by Judge William Stickman, I think it was November of last year. And that's a great one to read if you haven't read it. So if you haven't been paying attention, the Supreme Court has said, all right, there's this right of bodily integrity, which applies in the abortion cases where the government, you should have the freedom to make a choice, and the government cannot interfere with your bodily integrity. And that same government, and those same judges, those same lawyers, they're now arguing that, well, the same thing doesn't apply in the realm of vaccines, of forced vaccination. Those are two different things. One, because we like abortion, but we don't like the ability to make a choice about a vaccine. The fact is there is a substantial basis in the law for the right of bodily integrity, and that's freedom from government action, as is described in Roe versus Wade, Planned Parenthood versus Casey, the Cruzan case. In the Cruzan case, Chief Justice Rehnquist said every human being of adult years and sound mind has a right to determine what shall be done with his own body. Now, West Virginia case law has also recognized this right to bodily integrity and that it's a fundamental right. There was actually a recent decision, Cruz versus Fareed from 2019, where the West Virginia Supreme Court noted that all competent patients have the right to refuse medical care, and that right has been recognized by both the United States Supreme Court and by the legislature of West Virginia. And I included a bunch of that in our briefing. So there is a right to bodily integrity that's been recognized by the U.S. Supreme Court, by the West Virginia Supreme Court. This kind of led me to the discovery of a pretty interesting case. Let me see if I can find it. That came out of West Virginia. I think it was back in 1995. It was in federal court. Where is it? Yeah, here it is. I don't think I'd seen this case before. It's called In Re Cincinnati Radiation Litigation from 1995. And that was from the Southern District of West Virginia, federal court. And that happens to be the same federal court that this vaccine case is in right now. And this had to do with the Nuremberg Code. And that's something that has come up a lot with the vaccine litigation. It's something that we cited in our complaint as well, is that these mandates violate the Nuremberg Code. And this was really just an amazing case that I had never heard of from the Southern District of West Virginia. And this is really a crazy story that had to do with the government using radiation on people without their knowledge or consent. They were using human guinea pigs, and they took cancer patients, and primarily African American cancer patients. Unbeknownst to them, they were experimenting on them with radiation. I mean, that's the sort of stuff that you end up with if you allow this sort of legal logic, if you allow it to continue. That's where the government ultimately goes with it. They experiment on African American cancer patients without their informed consent, without their knowledge. And that was the facts that were involved in this In Re Cincinnati radiation litigation case. And again, tomorrow I will post this on the civilrightslawyer.com when it's filed. And I have all the cites and quotes out of that case. But I'd never heard about this case before. But they discuss, and that was a Section 1983 action on behalf of the family members of these people. And bodily integrity was discussed by the federal court in West Virginia at that time. So they said that constitutional law controlling the invasion of an individual's bodily integrity was clearly established between 1960 and 1972. And the court invoked the Nuremberg Code. And this is really interesting. The court quoted the Nuremberg Code, and it really applies to what's in dispute here. The voluntary consent of the human subject is absolutely essential. This means that the person involved should have legal capacity to give consent, should be so situated as to be able to exercise free power of choice without the intervention of any element of force, fraud, deceit, duress, overreaching, or other ulterior form of constraint or coercion, and should have sufficient knowledge and comprehension of the elements of the subject matter involved as to enable him to make an understanding and enlightened decision. This latter element requires that before the acceptance of an affirmative decision by the experimental subject, there should be made known to him the nature, duration, and purpose of the experiment, the method and means by which it is to be conducted, all inconveniences and hazards reasonably to be expected and the effects upon his health and person which may possibly come from his participation in the experiment. The duty and responsibility for ascertaining the quality of the consent rests upon each individual who initiates, directs, or engages in the experiment. It is a personal duty and responsibility which may not be delegated to another with impunity. So that is a quote from the Nuremberg Code, which a federal court in West Virginia invoked and used in this case in Ray Cincinnati radiation litigation in 1995. Now, some might ask, well, does the Nuremberg Code apply in federal courts in a Section 1983 case? Well, the court held in no uncertain terms that the Nuremberg Code is part of the law of humanity and that it may be applied in both civil and criminal cases by the federal courts in the United States. So, looking back at the excerpt of the Nuremberg Code that the federal court cited in regards to the radiation testing on cancer patient African Americans, they talked about somebody that has a legal capacity consent, somebody who has to exercise the free power of choice without the intervention of any element of force, fraud, deceit, duress, overreaching, or other ulterior form of constraint or coercion. Okay, so if it's a choice, if it's an allowable choice, and that satisfies federal law for somebody to choose to get fired, they don't want to take the vaccine, and their only choice is to choose to get fired, and the courts are okay with that. Well, how do you reckon that with the Nuremberg Code? How do you reckon that with Ray Cincinnati radiation litigation from 1995? There's no exercise of free power of choice. In fact, you have the intervention of duress, overreaching, constraint, coercion. You say, yeah, you have a choice, but the only other option is that you're fired. Which may mean that their home is foreclosed on. It may mean that they become homeless. It may mean that they won't be able to survive. I mean, it could mean any number of things. It's what we have here is way worse than 8 kids not wanting to attend a certain semester of school at Indiana University. And I think that is duress also and coercion also, but discharge from employment, I would argue, is much worse. That is not a free exercise of choice. That is an element of force, fraud, deceit, duress, overreaching. And the courts would not allow that in a Miranda rights waiver. They wouldn't allow a threat. They wouldn't allow negative consequences to be a part of the choice. They wouldn't allow that in a consent to a search. They wouldn't allow that. That's not voluntary consent. Therefore, the choice to be terminated from your job should not be a choice. That's pretty much it. That's where we are with the vaccine case. And it may be that YouTube will censor this video. I tried to leave some of the key words out of the description and the title, but we'll see. The other case I wanted to give an update on was the also infamous family court judge search case. We do have a document to share in that case now. All right, so this is one of the recent documents that came through in this case. So if you've been following basically the out of control family court judges in West Virginia, you would know that the judge that's featured in the video, in our case, was made the subject or the respondent of a disciplinary prosecution, and that's pending before the West Virginia Supreme Court. And now the family court judges have essentially rallied around this defendant family court judge and tried to interfere in that pending disciplinary case, and actually called for the firing of the disciplinary prosecutors, and have filed an amicus brief in her disciplinary case pending before the Supreme Court. So really outrageous scenario. And the last thing that's really happened here is that the judicial prosecutors filed a reply brief, and this just came through a couple weeks ago. But it's just, I mean, it's almost like you can't believe that you're reading some of this stuff. They were just so brazen. I'll just go over some of that briefly. I love how some of this is written. This is again from the judicial disciplinary prosecutors. What started as a simple story of admission/contrition has morphed into a twisted tale of omnipotence, hubris, slander, and revenge. It's clear from her June 24th, 2021 brief that respondent, this is the judge, wants to have her cake and eat it too. Through the course of these proceedings, the respondent went from admitting her wrongdoing and accepting responsibility for her actions to denying any misconduct but accepting her punishment. Now she's denying any transgressions, falsely claiming that the JDC, that's the judicial prosecutors, forced and or tricked her into an agreement, and advocating for no punishment or any alternative that mercy should the court find that she violated the code of judicial conduct. But in a nutshell, this judge violated all these different judicial ethical canons by forcing her way into Mr. Gibson's house without permission, searching his residence and seizing particular items, all in violation of the Fourth Amendment to the United States Constitution and its counterpart in the West Virginia Constitution, violating Mr. Gibson's due process and equal protection rights that are set forth in the state and federal constitutions, failing to follow the appropriate mechanisms for contempt proceedings, and engaging in inappropriate judicial investigation of the facts, which ultimately caused her to be disqualified from the underlying case. Her conduct was knowing and intentional, and it was egregious. She admitted to all the facts and violations that were contained in the formal statement of charges during the January 15th, 2021 hearing. What's even more troubling is respondent's flagrant disregard for the judicial disciplinary process and her attempts to undermine the integrity, independence, and impartiality of the court subsequent to the January 15th, 2021 Judicial Hearing Board hearing. While it's up to the court to determine what, if any, sanctions the Supreme Court should be imposed, which includes but is not limited to suspension without pay for up to 1 year for each violation of the code, the JDC, the prosecutors, request that the court impose a censure and a $5,000 fine in keeping with the agreement that the parties entered into. Now, so it's a good point that most people don't understand, is that in the judicial disciplinary process, the worst thing that they can impose on a family court judge is to suspend them without pay for up to 1 year. Well, that's because the family court judges are elected. So what's the only way to permanently remove an elected official? Well, either they agree to resign pursuant to some sort of agreement, or they have to be impeached by the legislature. And if you recall, in West Virginia, there were multiple Supreme Court justices not that long ago impeached for things including spending too much money on a purple velvet couch. I think it was velvet. So the legislature has impeached judges before, and that is the actual real remedy to take care of an out of control judge. So this is the disciplinary case. We also have the civil lawsuit in federal court pending, the Section 1983 case. And where that is they filed a motion to dismiss basically all of the defendants. You had the judge, you have the other lawyer that was involved, and you have the law enforcement officers who were involved. They've separately all filed motions to dismiss. The response briefs have all been submitted in those, and so we're just awaiting a ruling from the federal court on whether those claims can proceed. Meanwhile, the litigation is proceeding, and we've made it past the mandatory disclosure mark, the Rule 20, they're called the Rule 26 disclosures, and now we move into discovery. But meanwhile, this case is pending. The disciplinary case is pending before the Supreme Court. So it's just a probably the most interesting judicial disciplinary case I would imagine that there's been so far. And it was never supposed to be. The judge had entered into a signed and written agreement with the prosecutors that this is what the facts are. These are the violations I committed, and this is the punishment that we agree I should receive. That wasn't even in dispute until one family court judge who was supposed to be an unbiased member of the Judicial Hearing Board, threw a wrench into the whole thing and tried to take up for the respondent judge. And subsequent to that, the entire Family Court Judicial Association, which is a secretive organization that we haven't had access to their records. We don't even know who their secretary is. They've since met and issued a resolution and tried to send it to the Supreme Court in defense of this judge. And it's just really outrageous. So for that reason, I sent a FOIA request to their attorney asking for the actual roll call vote to find out who actually voted for this and to also obtain other communications. As of right now, they've denied that, but I'm continuing to pursue it. And that's basically what's happening in those cases. Let's see, I know I've missed lots and lots of questions. Jim, you're asking about the boot stomp case out of Greenbrier County. Well, it's funny you mentioned that because that lawsuit was filed in that case, and it is proceeding. And there's two different sets of defendants in that case. You have the state police, two state troopers, and then you have I believe it was a former Raynell City Police Department officer. Now, one side of that has been discussing, settlement, and the other side has been sort of dragging their feet. So as of right now, we're continuing with that case, and the next thing that will probably happen is depositions, which I really look forward to. I think that's a strong case, and if they don't want to settle that case, I look forward to proceeding and taking that one to a jury. Cam Huffman talking back now about the attorney for the family court judges, that their attorney is also a former family law judge. That's right. Out of Logan County, I believe. And so I asked her if she would accept the FOIA request on behalf of the family court judges, and she agreed to. And so her response eventually is that, well, since we're a private organization, we don't have to, we're not subject to FOIA. But I disagree with that. I think if you're acting as a elected family court judge, which this association is, you can't be a purely private organization that's exempt from FOIA. I mean, you can't have your cake and eat it too. So I think that if we're going to litigate that, they're going to lose, in my opinion. Gino, talking about the family court judges, can't they take their licenses to practice law? I don't think that the judicial disciplinary process handles that. I think that is for the attorney disciplinary process. And far as I know, there's not one pending there. But I would imagine if you get suspended as a judge, there probably would be some consequence as far as the underlying license to practice law as well. Alpha Fox Adam, in the wrongful discharge employment termination case, did you argue constructive discharge? No, we didn't need. And if you don't know, for those of you who don't know, constructive discharge is basically you were fired, but they didn't. You were fired, but you weren't fired. So, for instance, this might come up in sexual harassment cases a lot, whereas the victim slash plaintiff actually quit their job, but they quit their job because it was such a hostile and abusive work environment that that it was basically the same thing as them being fired. So, i.e., they were constructively fired or constructively terminated. So, no, we didn't need to argue that in this case because they put it in writing that they were terminating her. So it was we didn't even need to prove a constructive discharge. It was an actual discharge. Brian Cray, good question. Can't you make a complaint with the judge's counsel to investigate the cabal of judges? So what I think you're asking me is, hang on, can you can you file a judicial complaint against the judges who are interfering with the pending disciplinary case against this judge from the video? And generally in West Virginia, there's like a 2 year statute of limitations on judicial complaints. And to answer your question is I think absolutely somebody could file a complaint on these judges. But as of right now, nobody knows which judges actually were involved because they have this secret meeting and they have a secret vote. As of right now, it's secret. So there could be, we know that allegedly a majority of the judges voted to interfere and to call for the firing of the prosecutors, but there may have been judges there who did not participate in that vote or voted against it. So how do you find out? That's why I issued the FOIA request in part to get the roll call to find out. Not that I'm going to file a complaint, but I think the public deserves to know. Um, I've not let go of that effort, and I still want to find out because I think that the judicial ethical rules do say that a judge is not supposed to get involved or interfere with pending litigation that they're not presiding over as a judge. So, as the judicial prosecutors had pointed out in one of their briefs, every judge that voted to interfere in that case and try to get them fired has arguably violated one of the judicial canons of ethics. And yet they're still out there presiding over people's cases, making extremely important decisions on who will and will not have their children and what you walk away with out of a divorce, all sorts of things. And I think the public deserves to know. And so to answer your question is I think yes. And there's still time to figure that out. And it's outrageous that they've interfered, in my opinion. That being said, though, I think it's also, you know, important to wait and see what happens in this case that's pending right now. How can you file a complaint on a judge? Well, if in your state, for instance, in West Virginia, if you Google, if you go to the West Virginia Supreme Court's website, there's a link there for the Judicial Investigation Commission, and that is the disciplinary mechanism for judges in West Virginia. And there's instructions on with a form of how to file a complaint. And you have a 2 year statute of limitations in which to do so. And they do investigate those complaints. And they are very diligent with them. They're very prompt. But you have to have a legitimate complaint. I mean, you have to allege what the judge did, what happened, and which judicial canons that conduct violates. So if there was a conflict of interest that the judge did not disclose and that you have evidence of or information of, um, you put that in there, and then you list the rule that forbids conflicts of interest. And in the end, the judge who the complaint is filed against will have to respond to the Judicial Investigation Commission, and they'll make a decision. So it's a very easy process to do, and I hear a lot more people complaining and griping about judges than ever bothered to even file a complaint and to litigate those complaints. And in fact, it's very rare that I've ever talked to anybody who had a complaint against a judge, but ever actually made a complaint about it. And these complaints are investigated. I'm just looking back through some of the older questions here. Cam, you're talking about Judge Judy. She got her start in family court. I've actually seen Judge Judy's house before, and this was years ago. I don't know if she still lives there, but it was in Naples, Florida, and it was one of the biggest houses I've ever seen in my life. It was like, I don't know, 50,000 square feet or something like that. It was absolutely insane, right on the beach in Naples. Unless someone was pulling my leg, but everyone said that was Judge Judy's house. Okay. Another question here. Is 1 year a long time for a judge to sit on a ruling on a motion to dismiss? Pro se, I had to file a writ of mandamus to force the third, I'm not sure what state you're in, but um, just generally speaking, yeah, I mean, there's going to be an ethical rule probably in any state that says that judges have a ethical duty to rule on things, in a timely manner. So, I mean, there may be a set of facts that could be created where 1 year could be a reasonable amount of time if it was like, well, you probably couldn't come up with that set of facts. For instance, there was the opioid trial that just concluded in federal court here in West Virginia that is a bench trial that took 40 days to try. Now, how long is it going to take this federal judge to make a ruling in that case? I don't think there's any expectation that it would take a year or that a year would be reasonable. So I would think in pretty much any other factual scenario, a year would probably be not a timely ruling from a judge. Now there could be other reasons theoretically that maybe one of the lawyers screwed something up. I don't know. Okay, I've been told that Judge Judy was never a real judge. Can anyone confirm? Um, nope, I don't really care either. I don't know anything about Judge Judy other than, like I said, I saw her house one time. All right, Jason. Vaccine mandates. Can public schools in West Virginia ask if your child have been vaccinated for COVID since the vaccine is not FDA approved? I mean, we know that they're going to be able to do it. I mean, they're going to do it. I mean, the bigger question is whether public schools could force public school children, to be vaccinated for COVID. under a non-FDA approved? And I would argue no, but the lesson that we've been taught over the past year and a half is that really there's nothing that our government can't do to us anytime it wants to do us, wants to do it to us. I mean, and then the courts aren't going to stop them. Let's see, Cam, going back to that question, West Virginia family law rules provide that temporary order is to be filed within 1 business day after the hearing, and final order to be filed 30 days from the hearing. So, you know, that all these courts have their own operating rules. In my experience, the family courts are pretty quick at turning out orders in West Virginia. The circuit courts are, you know, the regular courts are, you know, can be very bad about just sitting on a case, you know, for example, for a year. I have seen that before. I've seen more than a year. And there's probably a rule against it as well. But, you know, rules get broken, and if nobody complains about it. And I've been in that, I've had that experience as well, to where you have something that a judge needs to rule on, but you don't want to be the one to complain about it, because there's that fear that if you're the one to complain about it, then all right, maybe you get the ruling and it's against you. So both sides are afraid to say anything, and it just sits there. All right, so that's probably enough for now. But anyways, sorry about the poor connection, and thanks for joining me. I will put an update on the website at thecivilrightslawyer.com probably tomorrow with the brief and the vaccine case. I'll probably do a few more revisions to it in the meantime. I have some other lawyers looking at it to get their suggestions, and then it'll be filed tomorrow. It'll go up tomorrow. Have some other big cases being filed here in the next couple of days. So make sure to subscribe here on YouTube, and also at, you know, for the email subscription, no spam, at thecivilrightslawyer.com. Civilrightslawyer.com. So I will hopefully get to do another live video in the near future, and hopefully the internet connection will improve. If not, I'll just have to use my other office. Also, stay tuned for what's going on with the lackluster YouTube channel copyright case. That's really developing quickly and is super interesting. And there's stuff happening behind the scenes on it. And so hopefully we can have an update soon on it. So until next time, have a nice evening, and I'll see you later.